In a medical malpractice trial in New York, do you know why you will rarely, if ever, see a case where doctor number one points a finger at doctor number two, and doctor number two points a finger back at doctor number one and says, hey, it was him, and the other guy says, no, it was him? You want to know why you rarely see this? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. When you bring a lawsuit seeking compensation for the harms and injuries you suffered because of some doctor's improper medical care, now if you sue multiple doctors, there are instances where you believe that one doctor is now accusing the other one. Hey, don't blame me, it was doctor number two. Doctor number two turns around and says, hey, don't blame me, it was doctor number one. He should have done X, Y, and Z. You will rarely, if ever, see that occur during the course of pretrial testimony or at trial. Now, why is that? Because the defense lawyers know very well that the moment the doctors are infighting amongst themselves about who is actually responsible, that makes our job so much easier. You see, we have to show to a jury that we are more likely right than wrong, that what we are claiming is true. And now, if the two doctors are fighting amongst themselves, hey, it was him, no, it was him, no, it was them, well, guess what? It just made our job so much easier. And now the jury simply has to decide what percentage each doctor is responsible, rather than deciding whether they're responsible at all. The moment each doctor fails to own up and take responsibility for his or her own actions, now if they start to point fingers at each other, it becomes a free-for-all, and now we just sit back and let them fight it out amongst themselves. He did it. No, he did it. No, he's mostly at fault. No, that one's mostly at fault. That turns out to be a great opportunity for us. But the defense attorneys know this, and the defense attorneys tell the doctors during pretrial testimony preparation, hey, listen, if you start to point fingers at somebody else, it's going to create a huge problem for defending the case. Instead, focus on what you did. Own up and take responsibility for what you did. And that's why, even if you believe that another doctor caused you harm, don't mention it, don't focus on it, don't point blame elsewhere. Simply talk about what you did and how your actions were appropriate. And that's typically how a doctor will be prepared for his pretrial testimony and for testimony at trial. But there is the rare case where the facts lend themselves to having the doctors pointing fingers at each other. And when that happens, it's a remarkable thing. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what could happen in a medical malpractice case here in the state of New York. You know, I recognize you've got questions or concerns about your own matter. Well, if you're contemplating bringing a lawsuit and your matter happened here in the state of New York, what I encourage you to do, if you've got legal questions, pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.